I want to show you some recent revisions to New Jersey's child pornography statute. And I gave you the text of the statute, and I mentioned in class last week that I had the opportunity to work on a government working group that I actually helped organize that had some significant input into the way this statute turned out. So one of the things that the statute tried to do was to talk about the age of who a child is, and you'll see here that the age to define a child was moved from 16 years to 18 years, so that anyone under the age of 18 would be considered a child for the purpose of child pornography. This does raise an interesting tension between who is a child for child pornography and the age of consent for children engaging in sexual, or young people engaging in sexual activity. Another aspect of the changes that were made to the statute were to increase the level of crime for certain activities and to increase the possible penalties. And the reason for this, really, talking with the prosecutors on the working group, was that judges, most cases of this sort don't go to trial. Most of them plead out, and judges had been reluctant to kind of put pressure on defense counsel to plead these cases out in a way that would involve any kind of jail time for the defendant. And judges, from the prosecutors I spoke with, at least some judges in the state courts, seemed convinced that it could be possible that some of this activity was a mistake, or some of it wasn't quite as serious. Maybe the person dabbled in it once or twice and were reluctant to impose jail time, and it made it difficult to plead those cases out in some ways. So the penalties were increased in part so that at the plea bargain stage there's less of an opportunity to argue that a particular defendant who really is engaged in this activity shouldn't have jail time. And that's what some of these kind of bump up provisions are designed to do. You'll see another one here, second degree crime. Now, a really interesting aspect, and I think a potentially controversial aspect of what we did with the New Jersey statute, was concerning the question of possession with intent to distribute. Because if you possess the file, it's one kind of crime. If you possess with intent to distribute, it's another kind of crime, and also another degree of crime. And the issue really arose where people were raising a defense that, well, I have a file sharing program like Kazaa or LimeWire, and by default the option to share files is enabled when you download those programs. And so yes, I had some child pornography on my hard drive, but I never intended to share it, and I didn't even know that the sharing button was enabled in Kazaa or LimeWire or whatever peer-to-peer program I had. Well, the statute now says that any use of a file sharing program to knowingly store or maintain an item which is designated as available for copying constitutes an intent to distribute. And notice these various provisions here that the state does not have to prove that any particular item had actually been searched. It's no defense that to say that, well, I didn't know the button was on. The state is not even required to prove that the defendant knew that this particular file was in the sharing folder. Simply the act of having a peer-to-peer piece of peer-to-peer software with sharing enabled and contraband child pornography in a folder that could be shared constitutes intent to distribute, constitutes a more serious crime. It's the prosecutors that I worked with thought this was really important. You can see how it potentially could be controversial. There also were provisions added to ensure that a person convicted of a crime, certain kinds of these crimes, have to serve a certain portion of their sentence. And again, part of the reason for this is so that in the process of plea bargaining, it's not as easy for defense counsel to argue that there shouldn't be jail time. In effect, for certain kinds of crimes, there's going to have to be some jail time. Another important part of this was the definition of how many items constitute what level of crime. And the statute still is key to the fact that if you have a certain number of files, that will influence what kind of crime, what degree of crime it is. And you'll see here that the degree of crime was bumped up, so just having 100 or more items is now a third degree crime instead of a fourth degree crime. Why is that important? It increases the potential penalty. And 100 items might sound like a lot, but the fact is that 100 items is really pretty small, and it is not difficult at all to acquire 100 photographs, as you know from just ordinary, legitimate kinds of photographs that you might have. So more often than not, if someone is caught, it's going to be at least 100 or more items. Another aspect was to require parole supervision for life. Again, the prosecutors I spoke with felt this was important because there's a high degree of recidivism, and of course because the crimes target children and victimized children. So, and this allows the government to monitor someone's computer activity. Note also that the statute specifically requires the disclosure of all passwords, including social media passwords. And this was, again, important to law enforcement, that they could monitor someone who has been convicted for life as part of the terms of their parole, monitor their social media. Now again, I recognize this could be controversial, and there are many concerns that people raise about laws like this going all the way back to Megan's Law and so on. And there are some legitimate kind of civil liberties concerns, but nevertheless, ultimately the legislature and the governor thought that it was important enough, the issue of protecting children was important enough that this provision should be included. So here's just a chart of the current New Jersey sentencing guidelines. I'll just leave it up on the screen for a minute. I won't try to read the whole thing, but you can see what the potential prison terms are, and you can see now that these kind of crimes are almost certainly going to carry some kind of mandatory prison term that is actually going to have to be carried out, and it's going to make it much more difficult for these cases to plead out without having the person being removed from society for at least some period of time. So the last piece of child pornography law in New Jersey that I wanted us to look at is the question of virtual child pornography. And recall last week that we looked at the federal law surrounding virtual child pornography, and there is an important case in New Jersey in the appellate division, State versus May, in 2003 that addresses the same issue. So in State versus May, the defendant is convicted of possession and distribution of child pornography, but claims the images were of dolls, and claims they were computer drawn, and so on, and were not actual children. Under cross-examination, the detective who examined the defendant's hard drive, as well as an expert retained by the state, were equivocal about whether the images could have been morphed images of adults or otherwise manipulated images in which no actual children were involved. And in effect, I think if you read the case, you can see that these both the detective and the expert were not really well prepared for this line of questioning. The defendant himself testified and said he believed that the images, in fact, were morphed images of adults, and they weren't actually images of children, and therefore there would be no violation of the child pornography statute. So the court noted that in Ashcroft, the U.S. Supreme Court had said that a child pornography law would be overbroad if it criminalizes simply virtual images, but also noted that Ashcroft didn't quite address the issue of morphed images. And the appellate division reverses and remands for retrial, and said that the prosecution on retrial must prove beyond a reasonable doubt that the images in fact were of real children and not of virtual children. So how would you do that? And again, at this time the statute was that for child pornography was that someone was a child if they were under 16. So direct proof is not required. You don't have to produce the actual children, which in almost every case would be impossible. The jury can infer from the images whether the children were below 16. You could do that possibly just based on outward appearance alone. It could be basically based on common knowledge, could be based on some kind of expert opinion. Obviously, if it's a photograph of a baby, you can infer that it's below 16. As they get closer to being 16 years old, you might require some expert testimony. And there are various ways in which you can present expert testimony that would be proof of age. I give you here a citation of a U.S. District Court case that has sort of a good litany of ways in which you can do that. But there are experts who can look at sort of the development of the sex organs and so on, even in a photograph, to give an opinion about whether the person depicted, in fact, is an adult who was just shaved to look like a child, or in fact is at a state of development in which the person is likely an adolescent, things like that. So the court notes that the trial court must examine each of the images, must make an assessment of each image. The trial court serves this gatekeeping function to determine which of the images have to go to the jury, and the jury has to be instructed that the state, in fact, bears the burden of proof. So that's our kind of very brief discussion. There are other cases we could talk about, but we've talked about a lot of cases already on the law of child pornography, both at the federal level and in New Jersey, and of course in every other state in the Union. There are statutes and cases dealing with similar issues.